Good morning, ladies and gentlemen. I'd like to welcome you to County Court at London 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at London 2. We have been asked to come to court today for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Now, your felony cases are referred to as your most serious type of criminal offenses, whereas your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious, it just means that they're not as serious as a felony case. And now, when I use the term serious, what I'm talking about the facts of the case, the possible punishment that a person can get if they're convicted. And so felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that cannot exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that cannot exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you don't have to worry about those type of punishments. Okay? Now, misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, Class C misdemeanors are cases that start in the city court or the municipal court or the JP court, which is the justice court. Now, they come to this court if a person is found guilty in that court, in one of those courts, and they appeal their case. And that's when they appeal the case, they're asking for a new trial. Okay? And they appeal the case, they get a new trial, and the case comes to this court. Now, the range of punishment for a Class C misdemeanor is a fine only. You only can be given a fine, you can't be given jail time. And the fine cannot be above $500. Okay? And so, Class C misdemeanors will be, for an example, will be like not having your seatbelt on, having an expired sticker, speeding. Those are just some examples of Class C misdemeanor. Now, as I mentioned to you earlier, you only going to be given a fine, you cannot be given jail time, and the fine cannot exceed $500. Now, if you fail to pay the fine, or if the fine is converted to community service and you fail to perform the community service, then the court can issue a warrant, which is called a capias pro fine, for your arrest, for you to either pay the fine or sit the fine out in jail. And if you sit it out in jail, you will be credited at $100 per day. Okay. Now, The next highest misdemeanor is a Class B misdemeanor. That was a Class C. Now we go up to the Class B. With the Class B misdemeanor, the range of punishment, if you're convicted, is minimum 0 days to a maximum of 180 days in the county jail, or you could be given a fine that does not exceed $2,000, or you could be given both such jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor. And if you're convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days in the county jail, which is 1 year. Or you could be given a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation is kind of referred to as deferred adjudication. And with that type of probation, it does not result in a conviction on your record. And if you successfully complete the probation, the case will be dismissed. You will not have a conviction on your record. And you may qualify for what is called a non-disclosure. I'll explain it to you. Non-disclosure is where your record is sealed to the general public. The general public cannot have access to you if you have a non-disclosure. They can't have access to that. Now, the operative word that I said was general public, which means that the government, and some certain government agencies that's listed in the Texas Code of Criminal Procedure can have access to, but most of the public is the general public. So, for example, let's say you're working at Mobile. They're not government, that's general, they can't have access. Okay? So most of the public is general public. All right. Now, the next type of probation is called adjudicated probation. We talked about unadjudicated probation. Now the other is called adjudicated probation. With adjudicated probation, or we call it regular probation, it does result in a conviction on your record. However, there is something that is called judicial clemency, which means that the court or the judge can set your conviction aside and you will no longer have a conviction. Okay, in order to qualify, 3 things has to happen. 1, you have to successfully complete the probation. 2, there cannot be any more time left on your probation. And 3, the probation office has to successfully discharge you or let you off of probation. If those 3 things happen, then the court has the discretion, or the judge has the discretion to set your conviction aside, and you will no longer have a conviction. Now, however, if you get another conviction later on, let's say you receive judicial clemency, you don't have a conviction, but you get another conviction for something else later on, then the case that you received judicial clemency on can be resurrected. It can be brought back up, and it can be used against you. And if you try to get a license with CPS, Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke or suspend your license. All right. Now, I'm getting ready to go over the paperwork that's on the clipboard. Everyone here for a case should have a clipboard. If you're here for your case and you do not have a clipboard, just simply raise your hand. Okay? Okay, everyone have a clipboard. Now, the first document on the clipboard is titled Judge's Explanation of Rights to Defendants Without Attorney. This is a document that I'm talking about right here. This 4-page document. This is a document you should be looking at. Okay. This document states that as a defendant in a criminal case, you have 3 options. 3 options regarding your right to have an attorney. All right. Number 1, you may hire an attorney. Number two, if you cannot afford to hire an attorney, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Those are your three options. Okay. Now, the first paragraph below number three states that if you want an attorney, you can hire and you can afford to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. The next paragraph, below that paragraph, states that if you want an attorney, but you do not have enough money to hire an attorney, you may request or ask that an attorney be appointed to represent you. But you must first fill out a financial questionnaire. Now, the financial questionnaire is a 3-page document that is also on that clipboard. Now, you will only fill out that document if you are requesting a court-appointed attorney. If you're not requesting a court-appointed attorney, you don't have to worry about that document. Okay? So for those of you who will be requesting a court-appointed attorney, that 3-page document is titled Affidavit of Injuries or Jefferson County Affidavit of Injuries. It looks like this. Okay. Now, for those of you who will be requesting a court-appointed attorney, you have to fill out the first page of this document. And then on the second page, at the top where it says Defendant's Oath, you just have to fill out this portion where it says Defendant's Oath on the second page. And then you go to the middle of the second page where it says Unsworn Declaration by Defendant. You'll fill this out and then you'll stop. Okay? Okay. Now, if we go back to this our first document, judge's explanation, the third paragraph below number 3 states that you may not speak to a prosecutor. Okay, a prosecutor is an assistant criminal district attorney, and we have 2 of them in court. They're sitting right here at this table. They work for the Jefferson County District Attorney's Office. If you had a lawyer, your lawyer would talk to them about your case. If you are representing yourself, you are your own lawyer. So you can talk to them about your case. But you cannot do that unless you first fill out a waiver of counsel. Now, this is only for people who will be representing themselves. If you're not representing yourself, you don't have to worry about what I'm getting ready to say. If you want to represent yourself, you have to fill out this document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You would read and sign this document, and then you'll have an opportunity to talk to the district attorney or prosecutors about your case to see if y'all can work out a settlement or whatever. Now, the next paragraph, this is paragraph, it's in block form. It's about 4 lines. It states, be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. That last paragraph, last 1-sentence paragraph down here states that if you're representing yourself, you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you're representing yourself. Let's say you talk to the prosecutors to settle your case. Let's say you want probation. But let's say the prosecutor said, well, I'm offering jail time. And you say, well, I don't want that. I want a lawyer. You can do that. Okay, you can change your mind. Okay, by representing yourself. Right, at any time. So All right, now, at the bottom of this document, in bold letters, now, at the bottom of this document, everybody in here for a case is gonna make a choice. There's 5, you can do one of those 5 choices. It says, defendant's choice, mark initials next to only one choice. If you are requesting time to hire an attorney, you will place your initials on the first line to the left. You sign this document at the bottom, it says defendant dated today's date, September 30th, and stop. This is the only document you have to sign. All right. The next line says if you already hired an attorney, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right of this. Okay? The third line states that if you would like to apply for a court-appointed attorney, you'll place your initials on the third line, sign and date this document. Then we'll go to the affidavit of injuries, like I mentioned earlier. You fill out the first page of this document, and on the second page, you fill out the top portion that's titled Defendant's Oath, and the middle portion at the bottom that's titled Unsworn Declaration by Defendant. That's only for individuals who will be applying for court-appointed attorney. All right. Now, the fourth line at the bottom is for person, if you've already been appointed a court-appointed attorney in the case, you'll place your name, your initials on the fourth line to the left, and the name of the attorney on the line to the right. Then you sign and date, and then you'll stop. Now, the last line to the left is for individuals who will be waiving their right to an attorney. Waiving means that you're giving up. You know you have a right, but you're waiving it or you're giving it up, and you would like to represent yourself. You'll place your initials on the fifth line at the bottom, sign where it says defendant and date it, and then we'll go to this document that is titled Waiver of Counsel for purposes of entering guilty plea or proceeding to trial. You will sign this document and date it, and that's it. Okay, before we go any further, or before I go any further, do you have any questions? Nobody have any questions? Okay. All right, now I'm gonna give you time to fill out that paperwork. I need to tell you about some other rights that you have. One other right that you have, one, you can enter a plea. A plea is you can tell the court that you enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be contesting or you will not be fighting the charges. Now, if you enter a plea of not guilty, then you're telling the court that, hey, I'm not guilty, I want a trial. Now, you have a right to have what is called a jury trial, where Mr. Cook is sitting in that area. We call that the jury box, shaped like a box. And 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to all of the evidence that's being presented by the state and by the defense, and then they will listen to the arguments of the defense and the state, and then they will go back into the jury room to deliberate, to decide whether to find you not guilty or guilty. You also have a right to waive your right to a jury trial, meaning that you have a right to give up your right to a jury trial. If you waive or give up your right to a jury trial and you still want a trial, you have a right to have what is called a bench trial. The reason why they call it a bench trial because it's a trial by judge only. The judge sits on the bench. The judge will be the judge and the jury in the case. And so the judge will listen to all of the evidence that's presented by the defense and by the state, and then the judge will listen to the arguments of the defense of the state, and then the judge would apply the facts of the case to the law, and then the judge will decide to find you either not guilty or guilty. Now, you also have a right to waive your right to have a bench trial. At that point, you're telling the court that I want to enter a plea of guilty and no contest, and so I want to talk to the prosecutor. You talk to the prosecutor to see if you can work out a settlement. The settlement we call a plea bargain. It's just called a plea bargain, the way to settle your case. Now, you've talked to the state. There's two types of plea bargain. One is agreed and one is unagreed. Agreed means that you and the state has come to an agreement as to what the punishment will be. For example, the example I used earlier, you wanted probation, the state wanted jail time, but now the state said, okay, I'll give you probation. You say, okay, I agree to that. Okay, that's an agreed plea bargain. Now, if you have an agreed plea bargain agreement, that agreement has to go before the judge. The judge could do one or two things. The judge can accept your plea bargain agreement or reject your plea bargain agreement. If the judge rejects your plea bargain agreement, you can tell the judge, well, since you're not accepting that plea bargain agreement, I take my plea back. In essence, I'm not pleading guilty and I'm not pleading no contest. You have a right to do that because it says, the law says you have a right to withdraw or take back your plea. All right. Now, if the judge does follow the plea bargain agreement, but let's say within 30 days after entering the plea, somewhere within that time, you say, you know what? I think I've been wrongfully convicted, or the court committed an error by convicting me and I want to appeal my case. Well, you have to get permission from the judge that followed the plea bargain agreement to appeal your case. Now, if the judge gives you permission to appeal your case is going to leave this court and it's going to go to the Ninth Court of Appeals, which is right above us on the third floor. There are 4 judges up there. They will listen to the evidence. They will, review the transcript, and they can do one or two things. They can grant or deny your appeal. If they grant your appeal, they can simply find you not guilty. Case over. Or they can send the case back down to this court and order this court to give you a whole new trial. All right? Now, if they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is called the Texas Court of Criminal Appeals, and they're located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review. I will explain that to you. Pro se means that by myself, I'm representing myself. And I'm petitioning the Texas Court of Appeals to review my case, to see if the Ninth Court of Appeals made a mistake, or to see if we wrongfully convicted you. Okay, or we committed an error by convicting you. They can do one or two things. They can grant or deny your petition. Now, if they grant your petition, they can simply find you not guilty. Case over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it right back down here with orders. All right? Now, if they deny your petition at that point, your conviction will stand. All right. Now, the next thing that could happen, you could have what is called an unagreed plea bargain agreement. What that means is this. You in the state have talked, you didn't like what they was telling you. You wanted probation, they wanted jail time, whatever. But you said, I'm guilty. I want to enter a plea of guilty. So I want the judge to decide what the punishment will be. We call that an unagreed plea bargain agreement. The judge will apply the facts. The judge will basically set your punishment anywhere within the punishment range. Anywhere from deferred probation, regular probation, jail time, fine, jail time, and fine. So that's anywhere within the punishment range. All right, that's unagreed. Now, you also have a right to have witnesses to come to court. Witnesses sit in that chair that has the microphone in front of them. We call that the witness stand. And when witnesses, what they can do, they can testify for you or they can testify against you. If you're representing yourself, you can ask some questions. If you have a lawyer, your lawyer can ask some questions. We call that either direct examination or cross-examination. Now, you can waive your right to have witnesses, which means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. Okay? Now, you also have what is called a Fifth Amendment right against self-incrimination. Fifth Amendment of the United States Constitution gives you the right not to justify in your case. The state, the government, the district attorney's office cannot force you to take the witness stand if you exercise or invoke your Fifth Amendment right against self-incrimination. And if you think about it just for a minute, it makes sense for us to have a Fifth Amendment right against self-incrimination. Why? Because the state of Texas or the government has the burden to prove that you are guilty beyond a reasonable doubt. Okay? You don't have to prove yourself guilty. Why should they put you on the stand for you to go up there and say, I did this? They have to prove that. You don't have to prove that. That's their burden, not your burden. Okay? And the other thing is, you can waive or give up your Fifth Amendment right against self-incrimination. Now, if you do that, then you will be taking a witness stand. All right. Now, I know a lot of times we watch television, we see shows like Law and Order, and we see a television lawyer go up to the witness and ask him a question, and the witness say, I take the fifth. What he's saying is, I'm exercising my Fifth Amendment right against self-incrimination. I'm not saying nothing, right? And so you have that, we have that right, okay, to exercise our Fifth Amendment right against self-incrimination. All right. Now, the next thing that I want to talk about is discovery. The word is saying discover like you're discovering something. Actually, what it basically means in law is you have a right to see the evidence that the state has in its file and it will be using against you. They just call it discover. I guess you have a right to discover or see the evidence. Now, that means that you have a right to see your statements, witness statements, police reports, lab reports, photos, video recordings, a right to hear audio recordings, a right to have access to documents or any type of instruments that they have, whatever evidence that they have, you have a right to have access to that. Now, you can waive your right to have discovery. If you do that, you're saying that I don't want to have access to the evidence. I don't want to see the evidence that the state has. All right. Now, everyone that's here today, charges been filed on you. You've been arrested, placed in jail. You're bonded out of jail. You're out of jail either on a cash bond, which means you pay the full amount of the bond to get out of jail, or you might be out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail. Or you may be out of jail on what we call a PR bond or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were just released under your own personal recognizance with a promise to appear in court. I've said that to say this. Every day that you spent in jail can be used as credit towards your punishment. So, for example, the operative word that I use is every day that you spend in jail can be used as credit towards your punishment. let's say you were booked in jail at 11:59 p.m. last night. And let's say you bonded out of jail at 12:01 a.m. this morning. In essence, you bonded out 2 minutes later. You were in jail 2 minutes. But you know what? You get credit for 2 days. Why? Because it's 2 different days. It's not 48 hours, right? It's 2 different days. And so every day that you spent in jail can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail. The state, you've talked to the state, and the state is offering you to serve 5 days in jail. You don't have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if the state is offering 7 days in jail and you serve 5 days in jail, that simply means that you would only have to serve 2 days in jail because you already have 5. We'll subtract 5 from the 7. That leaves 2. Now, every day that you spent in jail can also be used as credit towards your fine and court costs. For every 1 day that you spend in jail, you are credited at $100 per day that can be used towards your fine and court costs. So in our scenario, if you spent 5 days in jail, that's $500. So if the state is offering you fine and court costs of $500, you don't have to pay anything. Why? Because the time that you spent in jail has already paid it off. So you'll be, so the fine and court costs will be what we call taxed and retired. You don't have to pay it. Now, if they are offering fine and court costs of $700, you spent 5 days in jail, which is $500. We'll subtract 500 from your 700, that leaves 200. That means you would have to pay $200. Now, you'll be required to pay $200 on the day that your case is taken care of. If you cannot pay it, no problem. Because we can put you on what is called a payment plan to pay it off in small monthly installments until it's paid off. Now, maybe because of your financial situation, you are unable to pay it off on a payment plan. No problem. Because we can convert your fine and court costs to community service. And for every 1 hour community service that you perform at a nonprofit organization in Jefferson County, you will be given $12.50 credit toward that. So for example, your $200, let's say if you work 8 hours community service in 1 day, that's $100. So if you work 2 8-hour days, that's $200, and your fine and court costs is satisfied. All right. Now, Jefferson County District Attorney's Office has a program for first-time offenders. Let's say this is your first time having charges filed against you. The District Attorney's Office has a program which is called pretrial diversion, and with that program, they will dismiss your case and you can get it expunged off your record. Expunged means erased, deleted, or wiped off from your record, like it never happened. Okay? It's called pretrial diversion. Now, in order to qualify for the pretrial diversion program, you need 3 things. 1, it has to be your first time having cases filed against you. Okay. 2, you have to get a lawyer to assist you with the application process. Now, the lawyer could be a court-appointed lawyer. Don't have to be somebody hired. All right. And 3, it cannot be for an offense involving unlawful carrying a weapon or resisting arrest. Okay, but for all other cases, DWI, whatever, with all other cases, you can qualify. Now, if you are a veteran of any one of the branches of the United States military, the District Attorney's Office has another program that is called Veterans Court. It's for veterans only. With that program, you get into the program and complete the program, they will dismiss the case and you can get a non-disclosure where your record is sealed to the general public. All right. Only thing to get in that program is just that you're a veteran of one of the branches of the United States military. Now, this court, County Court at Law Number 2, Jefferson County, Texas, has a program that is called the CSI program. CSI stands for, it's an acronym that stands for Community Safety Initiative. It is a program that God led me to start in the first 100 days of taking office in March of 2017. The program is designed to address the issue of what we call recidivism. Recidivism is just a word that means people commit crimes over and over. So how do we prevent that? Well, with our Community Safety Initiative, or the CSI program, we have partnerships with various agencies in our Jefferson County area. One of the agencies that we have a partnership with is called Spindletop Center. Spindletop Center is our local mental health center for the Southeast Texas region. And what Spindletop will do, Spindletop has the expertise to address mental health needs. Now, you don't have to be incompetent or insane. You can just merely suffer from anxiety or depression or any other host of mental illnesses. Spindletop has the expertise to address those issues. Now, we have some representatives from Spindletop who will be coming forward in a few minutes. They're going to tell you more about the program. But basically, what Spindletop will do, they will conduct a private interview. They will do an assessment to determine what the issue is, and they will develop a treatment plan to address the issue. And that treatment plan could be the outpatient and inpatient treatment. Now, if you are an individual that have problems with maybe drugs or alcohol, well, Spindletop has another program that is called ATAR, ATAR, which is an acronym that stands for Addiction, Treatment, and Recovery. We also have a partnership with our local Drug and Alcohol Council that has a program that is called OSAR, OSAR, which is an acronym that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do a screening, an assessment to determine what the issue is, and they will develop a treatment plan for your issues with drugs and alcohol. If you're unemployed or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas, they will help you to get a job in the area that you're trained in. Now, if you haven't graduated from high school, if you do not have your GED, CICE also have a GED program which you can receive a graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we don't just give time, we take our time. And that simply means we do not just arrest the problem, we address the problem. And we believe that if you address the problem, you can produce productive people. And if you produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law Number 2 in Jefferson County, Texas, we don't have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community because what comes out of the home goes into the community. And so, if you're interested in any one of these programs, just let us know so that we can get you on the road to living your best life. And so, as I mentioned to you earlier, we have some individuals here from Spindletop. They're going to come right now and tell you just a little bit more about the program that Spindletop has to offer. We have Caitlin and Deputy DeVille. They're going to come and tell you a little bit more about their program. Okay.
Hello, good morning. I'm Josh DeVille with the Sheriff's Office. I'm an deputy with the Sheriff's Office. I'm attached to the Mental Health Division. And we're here to, the paperwork that we pass out, the little document to fill your names out, check the corrective boxes that you might be interested in. This is my partner, Caitlin. She's qualified as a health professional, and then she will be able to have a look at it.
On the little small paper on the front of your clipboard, that paper is optional. You do not have to fill it out. It is not a court document. So you can leave it blank if you prefer, and you can still turn it in while it's blank. If you like to get into mental health services or substance use services, just check the mental health box or the substance use box. And if you want to talk to me in person today about it, then you can write on your paper, please talk to me today. And when the judge is through with you, I'll come and find you and I'll pull you to a back room and then we can talk. All the other resources is I email you a form or website so you can fill it out yourself. But substance use and mental health is working with Spindletop or any other facility so you can get medications, talk to doctors, counselors, or support groups and classes. So if you're interested in any of that or you have any questions, just please write it on your paper and then I'll get to you and you can turn it in with your clipboard, okay? Yes, ma'am. Thank you.
Okay, thank you. At this time, we have Mr. Cook. He's with Texas Care.
Good morning, thank you, Judge. I talked to Mr. Joey Stewart, and he couldn't be here, but anyway, there's some pamphlets over there, if you have any domestic charges or
Oh, they are.
Texas Family Services. Anyway, I told him all that. My name is David Cook, I'm a peer support specialist for Texas Care. And I've been working in mental health for the past 3 years. I've kind of been sitting where y'all are, and it's kind of cool to be on the other side, you know. And I really appreciate the opportunity because when I had, my break, I used community resources, and so now I'm pushing community resources. So it came full circle, but it's really cool to be here to have this opportunity because in this opportunity, I'm jealous of that. This is out there now like that. It's kind of a good thing. Yeah. So I'm with Texas Care. We take Medicaid. We also work with children, 3 to 17, with behavioral issues or mental health problems. And we work alongside Spindletop. They're really good, a really great resource to have. And we have mobile qualified mental health professional counselors that go to the schools, or they will come to you instead of you have to make an appointment with school rep. So just glad to be here and I'd love to report it.
Okay, thanks a lot, Mr. Cook. Okay, now, ladies and gentlemen, the paperwork that you have, we're gonna give you some time just to finish filling it out. If you need help with the paperwork, just let us know. And we have our court personnel, as well as myself, who will be happy to assist you with completing and making sure that the paperwork is filled out properly. Now, once the paperwork is filled out, we're gonna pick the paperwork up, we're gonna evaluate it, make sure it's filled out properly. And then we're gonna call you before the bench, one at a time. Okay? And you're gonna be placed in one of 3 categories. 1, you want to hire a lawyer. 2, you want to apply for a court-appointed lawyer. Or 3, you want to represent yourself. Now, as I mentioned to you earlier, if you are requesting time to hire an attorney, your case will be reset today to give you time to hire an attorney. If you're applying for a court-appointed attorney, if you qualify for a court-appointed attorney, you will be appointed a court-appointed attorney before you leave here this morning. And 3, if you are representing yourself, You'll have an opportunity to talk to one of the two assistant criminal district attorneys, and your case will, if y'all come to an agreement, your case will be taken care of this morning, okay? So we're gonna give you some time to fill out the paperwork. Now, if you need to use the restroom, there are two restrooms right outside in the hallway. We have the men's restroom in front of County Court number 3. And on the opposite side of the hall, we have the women's restroom in front of the 172nd District Court. You'll be allowed to go out to always use the restroom. Please do not leave the courthouse. Okay? If you leave the courthouse and your name is not called, your bond will be forfeited. A warrant will be issued for your arrest. You'll be arrested, placed in the Jefferson County Jail, and guess what? We're gonna have to go through this all over again. All over again. And so, believe it or not, I've given this speech, and we still had people to leave the courthouse. And they came back. Some people learned the hard way. But anyway, please do not leave the courthouse. We want to see if we can get y'all taken care of in the next few minutes. As again, if you need some assistance with your paperwork, just let us know. Raise your hand. We have our court personnel. We'll be happy to take care of it. And the other thing is, be mindful that we're still in the courtroom. So conduct yourself accordingly. So at this time, the court will be in recess. Hold on a minute. Jefferson County Court at Law number 2 is back in session. The court is in session with the arraignment docket. First case is cause number 25 CCCR 1914. Case is style of the state of Texas versus Carson May Moore. Ms. Moore, would you please come forward? Ms. Moore, your full name is Carson May Moore?
Yes, sir.
Ms. Moore, would you please raise your right hand? Ms. Moore, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Moore, you may put your hand down. How are you doing, Ms. Moore? I'm doing fine, thanks for asking, Ms. Moore. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you would like to apply, that you would like to have your case reset to hire your own attorney?
Yes, sir.
Okay, Ms. Moore, before you sign and initial this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Ms. Moore, I read your answers. Now, Ms. Moore, your case will be reset to give you an opportunity to hire your own attorney. Our court coordinator is going to reset your case. Once your case is reset, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall, right there.
Yes, sir.
Okay.
I haven't got it reset in 3 weeks. But when they give you a reset, can you give us up? You can send us out and just do the same day.
Next case is cause number 25 CCCR 1, let's see, cause number. Yeah, cause number 25 CCCR 1898. Case is style of state of Texas versus Taylor Monette Neville. Miss Neville, your full name is Taylor Monette Neville?
Yes, sir.
Ms. Neville, would you please raise your right hand? Ms. Neville, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Neville, you may put your hand down. How are you doing, Ms. Neville?
I'm doing wonderful.
That's good. Ms. Neville, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to have your case reset to hire your own attorney?
Yes, sir.
Ms. Neville, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay. Ms. Neville, your case is going to be reset to give you an opportunity to hire your own attorney. Now, Ms. Neville, our court coordinator is going to reset your case, but before she resets the case, I need the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Code at Law number 2. Do you see that document?
Yes.
I'm going to go over this document with you, and it states, following the return of a criminal information in County Code at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court.
Yes,
The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs, alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant states that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that
Yes,
condition?
sir.
Condition number 4 does not apply, however, condition number 5 does apply. Condition number 5 states the defendant is prohibited from possession of firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Ms. Neville, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested, placed in the Jefferson County Jail. Now, Ms. Neville, your case is going to be reset by the court coordinator. You're going to have a seat in that first chair on the wall. Wait for your name to be called. Travis Smith. This is clause number 25 CCCR 1688, case of style of state of Texas versus Travis Smith. Mr. Smith, is that your full name?
Yes, sir.
Okay, Mr. Smith, would you please raise your right hand? Mr. Smith, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Mr. Smith, you may put your hand down. How are you doing, Mr. Smith? That's good. Now, Mr. Smith, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Okay, is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to that you would like to have your case reset to hire your own attorney?
Yes, sir.
Is that correct? No, it says that you've already hired Frank Adams.
Yes.
Is that correct?
Yes.
Now, before you signed and initialed this document, did you read the document?
Mhm.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes.
Okay. Mr. Smith, I read the answers. Based on your answers, your case is going to be reset by our court coordinator, give you an opportunity to hire, for Mr. Adams to send the court a letter of representation. He has to send the court a letter of representation, inform the court that he has been hired to represent you. Okay? So what you probably need to do once your case is reset is contact Mr. Adams, let him know that, well, let me do this here. Could we check to see if we have a letter of representation?
We don't.
We don't? Okay. Contact Mr. Adams and let him know that he needs to send the court a letter of representation in your case. Okay? Now, Mr. Smith, I need to give you some bond conditions. Mr. Hilton, if you don't mind, could you hand these bond conditions to Mr. Smith? Thank you. Now, Mr. Smith, you just been handed a document that is titled Standard Bond Conditions in County Court at Law Number 2. And I'm going to go over this document with you. Okay, it states following return of permanent information in County Court at Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? And condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Okay, and Condition number 4 does not apply, that only applies in the DWI case. Ms. Mosley.
Yeah.
Could I give me his bond conditions back? I need to, here you go. Okay, now, condition number 5 states that the defendant shall wear a global positioning monitoring system device at the defendant's expense with written verification being submitted to the court within 3 days. Do you understand that?
Yes, sir.
Okay, now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. Your case is gonna be reset. Stand, have a seat in that, that first chair. You need to give him a locations of the global position monitor, okay? Just stand in front of the court coordinators. Once your case is reset, you're free to go and you have a blessed day. There you go. Who's that? Martin Gamans? John Hargis? Hargis? Good morning. Okay. This is cause number 25 CCCR 1672, case of style the state of Texas versus John Timothy Hargis. Mr. Hargis, would you please raise your right hand? Mr. Hargis, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Mr. Hargis, you may put your hand down. How are you doing, Mr. Hargis? That's good, Mr. Hargis. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney? Now, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read? Is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Mr. Hargis, I read your answers. Your case will be reset to give you an opportunity to hire your own attorney. Mr. Hargis, just please have a seat in that first chair. Wait for your name to be called. Once your name is called, you go to the window, and once you finish at the window, we'll be free to go and you have a blessed day. Thank you. Shelley Smith. Ms. Smith, how are you doing? Ms. Smith, your full name is Shelley Smith?
Yes. She's hard.
She hard of hearing?
Yeah.
Okay, Ms. Smith, your full name is Shelley Smith?
Your full name is Shelley.
Yes, sir.
Okay, Ms. Smith, please raise your hand, your right hand, the other hand, your right hand. Yes. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Yes.
Okay, now, Ms. Smith, you can put your hand down. You can put it down. How are you doing, Ms. Smith?
Okay,
You doing okay?
I wanna go home.
Okay, you'll be going home pretty soon. Now, Ms. Smith, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Now, Ms. Smith, we went over this document, is that correct?
Yes, sir.
And this is your signature on this document, right?
Yes, sir.
And I have another document that's titled Affidavit of Indigence. And we went over this document too, right?
Yes, sir.
And on page 2 of this document, this is your signature, Shelley Smith.
Yes, sir.
And on the first document, judge's explanation, this is your signature also, right?
Yes, sir.
And your initials SS, oh, Shelley Smith, right?
Yes, sir.
All right. Now, before you sign these documents, we went over all of these documents and you understood what we went over. Is that correct? All right. Now, Ms. Smith, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Marcus Wilkerson.
Marcus Wilkerson.
Wilkerson, yes. Our court coordinator is going to give you information on how to contact Mr. Wilkerson. And Mr. Wilkerson is going to be given information on how to contact you.
Yes.
All right? So just have a seat in that chair and wait for your name to be called, and you have a blessed day.
Thank you. Bye.
You're welcome. Daryl Romar. It's on one of those sheets.
It is?
I don't know if it's on that one. It might have been on that other sheet that we had for spindle top. It's not on that one. He'll write it down.
Yeah. It's getting- right here.
No, I don't think I wrote Wilkerson's name down in that. Didn't that before? Okay, no, that's fine. Just write Wilkerson's name down on the back page. Okay. This is cause number. Two-five CCCR 1946. Case is styled the state of Texas versus Darrell Wayne Romar Jr. Mr. Romar, is that your full name?
Yes, sir, it is.
Mr. Romar, would you please raise your right hand? Mr. Romar, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Romar, you may put your hand down. How are you doing, Mr. Romar? That's good. Now, Mr. Romar, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir, I do.
Is this your signature on the line that's titled defendant?
Yes, sir, it is.
And are these your initials on the line that state you would like to apply for a court-appointed attorney?
Yes, sir, it is.
I also have another document that is titled Affidavit of Indigence. Do you recognize this document?
Yes, sir, I do.
On page 2 of this same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir, it is.
Mr. Romar, before you signed and initialed all of these documents that I just showed you, did you read the document?
Yes, sir. I did.
Did you understand what you read?
To the best of my ability, yes, sir.
Okay, and that's always gonna be my next question. Is everything in this document true and correct to the best of your knowledge?
Yes, sir, it is.
Okay. Mr. That door is locked. You gotta go through the other door. That door right there. Okay, now, Mr. Romar, your, the attorney that will be appointed to represent you is Attorney Langston Adams. Attorney Adams will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall.
Sir, thank you.
You're welcome. I need to sign Ms. Smith's paperwork too. Ms. Smith, the affidavit of insurance. Thanks. This is Romo. Stephen Lee. This is cause number 25 CCCR 1974, case of style of state of Texas versus Stephen Lee. Mr. Lee, is that your full name?
Yes.
Mr. Lee, would you please raise your right hand? Mr. Lee, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Mr. Lee, you may put your hand. How you doing, Mr. Lee?
Same better, but same words that.
I hear that. Okay, Mr. Lee, I have before me two documents. First document is titled Judge's Explanation of Rights to Defend a Side Attorney. You recognize this document? Is this your signature on the line that's titled Defendant?
Sir.
Or these your initials on the line that state you'd like to apply for court appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Lee, before you sign and initial these documents, Did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Um,
Okay, Mr. Lee, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Don Boudreaux. Attorney Boudreaux will be given information to contact you, and you will be given information to contact him. Our court reporter will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat and wait for your name to be called by the court coordinator.
sir, you-
Thank you. Jaden Moore. Ms. Moore, your full name is Jaden Janae Moore. Ms. Moore, would you please raise your right hand? Ms. Moore, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? You have to speak up. Okay, Ms. Moore, you may put your hand down. How are you doing, Ms. Moore? That's good. And Ms. Moore, you represented in your case. Well, you're not, Ms. Moore, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant? Or are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indians. Do you recognize this document? On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature? Okay, now, Ms. Moore, before you sign and initial these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Moore, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Tom Burbank. Attorney Burbank will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, but before she gives you that information, I need the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court Law Number 2. I'm going to go over these bond conditions with you, and it states, following return of accrued information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? You understand that condition? Okay, and condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Condition number 4 doesn't apply. That only applies in a DWI case. Your case is not a DWI case. However, condition number 5 does apply on the next page, and it states that defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Ms. Moore, if you violate any one of these bond conditions, your bond can be revoked, and if your bond is revoked, warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Okay, now, Ms. Moore, you're gonna have a seat in that first chair and wait for your name to be called. Martin Gamaz. Okay. Let's see. Your full name is Martin Enrique Gamaz Jr.?
That's correct.
Okay, Mr. Gamaz. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Gamaz, you may put your hand down. How you doing, Mr. Gamaz?
I'm good. How are you?
I'm doing fine, thanks for asking, Mr. Gamaz. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Gamaz, do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes,
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
that's correct.
I also have another document that's titled Jefferson County Affidavit of Injuries. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Mr. Gamaz, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
That's fine.
Okay, now, Mr. Gamaz, let me do this here. I need to ask you. So, Mr. Gomez, we made one correction. And we changed where your income on this line. Is that correct?
That's correct.
And so everything in this document is true and correct to the best of your knowledge.
Correct.
Okay, so, Mr. Well, everything on all of these documents is true and correct to the best of your knowledge?
That's correct.
Okay, so Mr. Gomez, the court will find that you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Christy Cawthon. Okay? Ms. Cawthon will be given information to contact you. And you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Now, before she gives you that information, I need to give you some bond conditions. Mr. Gomez, would you please step to your left and I can hand this bond conditions to you? And then you can step back. Okay, Mr. Gomez, the document that you have before you is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that?
Yes.
Okay, I'm going to go over this document, which it says following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes.
Condition number 2, the offender shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes.
Condition number 4 does not apply because it only applies in a DWI case, a driving while intoxicated case. Your case is not a driving while intoxicated case. Condition number 5 on the next page does apply, and it states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
And condition number 7 states the defendant shall wear a global positioning monitoring system device at the defendant's expense with written verification being submitted to the court within 3 days. Do you understand that condition?
Yes.
Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. So just have a seat in that chair by the wall, wait for your name to be called. Once your name is called, you'll go to the window and get your case reset and information on the GPS, and you have a blessed day. We have any, please, Reverend? Dismissals? Oh, okay. Patrick George Pleasant. Hmm? Okay, okay, okay. Now, this is cause number 24 CCCR 2774. Case is styled the state of Texas versus Patrick George Pleasant. Mr. Pleasant, is that your full name?
Yes.
How are you doing, Mr. Pleasant?
Could be better.
Okay, could be worse too.
How you doing?
I'm doing fine. Yeah,
This is
it's another day that the Lord has made. I will rejoice and be glad in it. And the state is represented in this case by Attorney Shane Hilton. Mr. Hilton, how are you doing?
I'm good, Your Honor. Thank you.
You said what?
The state is represented by Mr. Shane Hilton. And now, Mr. Hilton, I have before me a document in cause number 24 CCCR 2774. It's a motion to dismiss this case. Is that correct?
That's correct, Your Honor. That came with the agreement for dispelling.
Okay. And Mr. Pleasant, I just signed the dismissal. You'll be able to get a copy of this dismissal. Once you get a copy of this dismissal, you'll be free to go and you have a blessed day.
Your Honor, he still has the call number 0810.
Yeah, he's represented by Rife Kimball on that. I don't know.
We need to do
What?
a reset or,
We're gonna have to reset it. I understand Rife is in another court out of county.
yes, Your Honor. I just wanted to make sure before he left that he did have.
Yeah,
to
he's
reset
gonna get a
us.
reset.
All right.
Okay, so the case will be reset. The one that's still left. All right, you can have a seat, wait for your name to be called. Once your name is called, you're free to go and you have a blessed day. Okay, the tablet. Is that Caldwell?
Yes.
Yes, Your Honor.
Is Berlin James Caldwell? Mr. Caldwell, your full name is Berlin James Caldwell?
Yes, sir.
Okay, how are you doing, Mr. Caldwell?
I'm doing well. How you doing?
I'm doing fine, thanks for asking. And Mr. Caldwell, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Caldwell, you may put your hand down. And Mr. Caldwell, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Law Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state
Yes, sir.
you like to waive your right an attorney to represent yourself? I also have another document that's titled Waiver of Counsel for purposes of entering guilty plea or proceeding to trial. Is this your signature on this document?
Yes, sir.
Before you sign and initial these documents, did you read the documents? Did you understand what you read?
Sir.
And is everything in these documents true and correct
Yes.
to the best of your knowledge?
Yes.
And let's see. And state, I have before me a motion to dismiss this case. Is that correct?
That's correct, Your Honor.
And Mr. Caldwell, I'm signing this motion to dismiss this case. You'll be able to get a copy of this dismissal in a few minutes from our court coordinator. Once you get a copy, you'll be free to go and you have a blessed day. Please have a seat in that first chair and wait for your name to be called. You're welcome. We have Bonilla. Angelina Bonilla. Huh? Oh, how do you pronounce your last name?
Bonilla?
Bonilla?
Yes.
Okay. Ms. Bonilla, would you please raise your right hand, Ms. Bonilla? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Bonilla, You may put your hand down. Now, Ms. Bonilla, I have before me two documents. And before we go any further, how are you doing today?
I'm good, how are you?
I'm doing fine, thanks for asking. Now, Ms. Bonilla, first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes,
And is this your signature on the line that's titled Defendant?
yes,
And are these your initials on the line that state you would like to waive your right to an attorney and represent yourself?
yes, sir.
I also have another document that is titled Waiver of Counsel for purposes of inter guilty plea or proceeding to trial. You recognize this document? And is this your signature on the line that's titled Defendant? Now, Ms. Bonilla, before you signed and initialed these documents, did you read the documents?
Yeah.
Did you understand what you read?
A little bit,
What you said a little bit?
yes.
You said, what didn't you understand? Now, the first document is this document that I went over and I explained to you the rights that you had as a defendant in a criminal case, the right to have an attorney.
Mhm.
Did you understand everything on this document? Okay. The second document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea. And it states, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. I have been advised this 30th day of September 2025 by County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Do you understand that?
Yeah, okay, yeah, now I understand.
Okay. Now, is everything in these documents true and correct to the best of your knowledge?
Yes,
Okay. Now, Ms. Bonilla, I understand that you've talked to the prosecutor. Is that correct?
yes, sir.
And you you will be setting up an appointment with the district attorney's office to view a video.
Yes,
Okay. So we're going to reset your case. And once your case is reset, you'll be free to go. Make sure that you talk to the prosecutor so y'all can get a date so you can go in and view the video. All right. Have a seat in that first chair on the wall. You're welcome. Hold on a minute.
Yeah, might be happening.
Jefferson County Court at Law number 2 is back in session. The court is in session with the arraignment docket. Next case is cause number 25 CCCR 1976, case of style of state of Texas versus Stephen David Underwood. Mr. Underwood was scheduled to be in court at 9 a.m. At about 9 a.m., the court's bailiff called the name of Stephen David Underwood at the courthouse door. Stephen Underwood did not answer. Well, Mr. Underwood has not appeared in court since the court has been in session. The time now is 12:16 p.m. on today's date of September 30th, 2025. Ms. Bailiff, would you please call the name of Stephen Underwood at the courthouse door?
Yes, sir. Stephen Underwood. Stephen Underwood. No response, Your Honor.
Stephen Underwood's name was just called at the courthouse door. Stephen Underwood did not answer. A reasonable time has passed to give Mr. Underwood an opportunity to appear in court. State, do you have a motion?
State moves for bond.
That motion will be granted. Stephen Underwood's bond will be forfeited and warrants will be issued for his arrest. And cause number 25 CCCR 1976. Next case is cause number 25 CCCR 0958. Case is filed in the state of Texas versus Cottrell Tariq Calhoun. Cottrell Calhoun was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Cottrell Calhoun at the courthouse door. Cottrell Calhoun did not answer. Cottrell Calhoun has not appeared in court since the court has been in session. The time now is 12:17 p.m. on today's date of September 30th, 2025. Ms. Bailiff, would you please call the name of Cottrell Calhoun at the
Yes.
courthouse door?
Trail Calhoun. Calhoun. No response, Your Honor.
Cottrell Calhoun's name was just called at the courthouse door. Cottrell Calhoun did not answer. A reasonable time has passed to give Mr. Calhoun an opportunity to appear in court. Has not appeared in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Cottrell Calhoun's bond will be forfeited and warrant should be issued for his arrest. And cause number 25 CCCR 0958. And this will conclude the calling of the court's arraignment docket on today's date of September 30th, 2025 in County Court at Law number 2, Jefferson County, Texas. Judge Terrence Holmes presiding. Our court will be in recess until 1:30 to resume with the trial scheduled at 1:30. Okay, everyone, please have a blessed day.
Oh, we can go.